So, Mika, we also have some disturbing news coming out of the courtroom yesterday.
Yeah, we'll get back to Biden. The Coast Guard lieutenant accused of planning a terror plot against politicians and journalists and TV hosts will not face terrorism-related charges and could be released. The Associated Press reports that a federal judge said that 50-year-old Christopher Hasson is eligible to be released on bail as he awaits trial on drug and firearm charges because prosecutors have not charged him with any terrorism-related offenses. U.S. District Court Judge Charles Day said yesterday that he still had grave concerns about Hasson and could not justify holding him. He could be released in the coming days after the judge sets conditions. Judge Day said he will hold another hearing to work out a supervision arrangement that will include electronic monitoring and other measures before Hasson's release. In new court filings this week, federal prosecutors argue that Hasson, quote, continues to pose a serious danger. However, his attorneys say the accusations against him are overblown. Joining us now, State Attorney for Palm Beach County, Dave Aronberg, and MSNBC legal analyst Danny Savolas.
So, Dave, help me out here. This guy was found with a massive weapons cache, silencers, which obviously are used only for the purpose of quieting guns when you're shooting people. He had a manifesto. It was inspired by a Norwegian terrorist who gunned down 70 children in a summer camp. A white nationalist, and he had Nancy Pelosi and Chuck Schumer and Democratic candidates running for office, as well as TV hosts, yours truly, on that list. He had the means to carry out his manifesto, his murderous manifesto, and basically he wanted to decapitate the Democratic Party. How does a judge, first of all, let him go? And secondly, how does Attorney General Barr sit on this case and not let his U.S. attorneys charge this guy with something else?
Yeah, Joe, the reason why so many prosecutors have dark circles under their eyes is because we lose sleep over cases like this. I mean, here you've got a self-professed white nationalist with a stockpile of weapons and ammunition with his target list and his manifesto. And the judge himself said, you know, he needs supervision. He's got grave concerns, that he needs eyes and ears on him like nobody's business. But the law is what it is, and he's not being charged with international terrorism. He's not even being charged with violent crimes, which could keep him behind bars. And as far as whether he should be charged with domestic terrorism, there is no separate federal statute on domestic terrorism, and that's something Congress perhaps should address.
But I have to ask why. How could this be? Danny Savolas and then Dave Aronberg, these are the things that you find after a massacre, and you go, oh, these were the warning signs. We should have noticed them. So the warning signs are right there. And I say this as the wife of someone who was on that list, so you may hear a little intensity in my voice, but I think Trump's doing this. How can I not do that math in my mind? That the Attorney General is making a clear decision here to make sure the lives of people who are being targeted are continue to be in danger because they will not put together the pieces of this case. A stockpile of weapons, a list of people that he wants to kill. Are you serious? There's no way not to let this guy walk. You've got to be kidding me. Someone give me a legitimate reason. Danny, try.
I'll try. Mika, the Attorney General is constrained by the law and the DOJ policies. And in this case, there are no domestic terrorism charges. That's something Congress can take up. And in addition, the judge and the AG are constrained by the law. The Bail Reform Act requires bail unless there are no circumstances that will assure the safety of the community. And reasonable minds can differ on whether or not the community will be safe if this person is released.
But Danny, hold on. Let me just stop.
There's always a way around it, and you know it.
If somebody threatens the President of the United States, they're thrown in jail.
That's right.
If this guy had put the President of the United States on his kill list,
things would be different.
Hold on. Instead of the Speaker of the House, and the Senate Minority Leader and Democratic presidential candidates, that person would be in jail, that person would stay in jail.
That's partially right, because threats against the president are a separate federal crime. What you have here and what the judge recognized is that, unfortunately, in our law, it is legal to have the most hateful, violent thoughts and even put them down on paper. But the Attorney General is required, not just if he has probable cause, he has to believe under DOJ policy that he has this case beyond a reasonable doubt. And in American law, there is a huge gray area between perfectly legal, evil thoughts and actual acts. And in this case, at its core, you have unlawful possession of firearms by an addicted person that's alleged, and then a simple possession of drugs. All of that other intent in the writings and the hateful speech is really going to be a close call for a jury if he's charged with some kind of terrorism. And again, we don't have domestic terror charges in this country. So this has always been a challenging case from the prosecution, and it was a challenging case for the judge under the Bail Reform Act to decide whether or not to release him. And he's not being released into the community at large. He's going to have EM, electronic monitoring. He's going to have a curfew. He's going to have to turn over all his guns. He's going to be watched.
Yeah.
So,
Great.
so Dave, so if somebody threatens the president of the United States, they're in trouble and they get sent to jail. But if you have a plot to kill the Speaker of the House, the third highest ranking constitutional officer, you're fine. You get out of jail, even though you have the manifesto, you have the weapons, you have the plans, you have the means, and you've expressed that you're going to kill the Speaker of the House. Then you're fine?
No.
Well, Joe, it depends on what federal prosecutors charge you with. In general, under federal law,
But see,
defendants are entitled.
isn't that the rub right there? What federal prosecutors decide to charge you with.
And they didn't.
And they didn't. And Barr didn't. And the U.S. Attorney didn't. And yet, when the Republicans got gunned down, of course, everybody was asking, why didn't we do something before Steve Scalise and other Republicans got shot
So many
at?
warning signs.
Who in the hell would look at this manifesto and then say, you know what, this might be a tough case. I don't know if we want to move it forward or not. Who would do that after Steve Scalise's shooting, after the white nationalism that's exploding across America?
Yeah, Joe, these are all fair points. I understand your passion and Mika's passion on this. Under federal law, defendants are entitled in general to pretrial release unless they pose a flight risk, or if they're going to obstruct justice, or if they pose a danger to the community, which you would think would be in this case.
Yeah,
but I think
that's good. I think you could actually check that box off, William Barr.
But, you know, it usually boils down to whether or not the defendant has been charged with a crime of violence. And here the defendant is only charged with weapons and drug possession, not any crime of violence. Here's the irony in this. If he were caught with a kilo of cocaine, he would likely be sent to jail pending trial, because many drug charges are considered crimes of violence. But here he was charged with possession of tramadol, which doesn't qualify. So the system definitely does have its inconsistencies.
And the Attorney General has a lot of ability here to impact this, and he has chosen not to.
Yeah.
Duh. I wonder why. Willie.
Yeah, Danny, just to follow up on the detainment piece of this, the assistant U.S. attorney said in this case, and said again this week, that it's clear to him that this man poses a clear threat to the public. He poses a danger by being out of jail. Is there any method by which he can be detained, even if they don't bring charges?
No, I mean, ultimately they have to bring charges in order to detain him. There must be pending charges. And you bring up a good point
Danny, hold on a second. I'm sorry, I don't mean to interrupt, but who makes the decision to bring those charges?
The U.S. attorney in that district, and arguably you could say that AG Barr can make a decision on that.
Yeah,
the Justice Department
makes that decision. Go ahead.
You mean the president's lackey?
Yeah, go ahead.
So in this case, I'm glad Willie pointed out, the government is arguing strenuously for pretrial detention in this case. The judge recognizes that the Bail Reform Act requires at least bail opportunity if there is not a crime of violence or some other certain conditions where there's a presumption of detention. And the idea behind that, unfortunately in this case, is that defendants generally are entitled to bail. And that doesn't mean, again, he's going to walk free. He's going to have restrictions.
Dave Ehrenberg and Danny Cevallos, thank you guys both so much. And, you know, listen, I want to be really clear here. Mika may have her reasons for being upset about this. I'm not upset personally. What I'm upset about is that there is somebody that has been inspired by a white nationalist who killed 70 children at a day camp and blew up 6 people in Oslo with a bomb on the same day. This guy has written a manifesto claiming to be inspired by him. And what concerns me is he's targeted Nancy Pelosi. He's targeted Chuck Schumer. He's targeted all Democratic senators that have decided that they're going to run against Donald Trump. And he's targeted people in the media who've been seen as critics of Donald Trump. I mean, the consequences of this, the long-range consequences of this, are shocking. And it goes back to what I said just a week or two ago about the Attorney General, that the biggest dangers, the biggest threats ahead to our constitutional republic would be if he continued to be a hack in deciding who he was going to prosecute and who he was not going to prosecute.
And here we are.
There is no other Attorney General who would see the 3rd highest ranking person in the land on a kill list from a self-professed white nationalist inspired by a Norwegian mass murderer and say, you know what, I don't know if I can make this case or not. We're just not going to charge him. It's absolute nonsense. This is all in the Attorney General's hands, and I hope that the Democrats that are out on the campaign trail, I hope the Speaker's office, I hope the lawyers at CNN, the lawyers at other networks, the lawyers at this network will start pressuring the Attorney General, start pressuring the U.S. Attorney, start pressuring the judge to not let this domestic terrorist in training out.
Still ahead on Morning Joe, Bob Mueller says Don McGahn is, quote, a credible witness with no motive to lie or exaggerate. Judging by his Twitter account, President Trump feels otherwise. As NBC analyst Matt Miller pointed out, the president is weakening his already paper-thin executive privilege claim with every tweet. We'll talk about the president's new denials surrounding obstruction. You're watching Morning Joe. We'll be right back.
Thanks for checking out MSNBC on YouTube, and make sure you subscribe to stay up to date on the day's biggest stories. And you can click on any of the videos around us to watch more from Morning Joe and MSNBC. Thanks so much for watching.